First of all, I'd like to say my apologies, everybody. As I told yesterday, we'll be having class in morning, but unfortunately, madam was not available, so we are planning evening. Okay, sorry for the inconvenience. Okay, I'll take a short moment to share my screen. Once it is visible, say yes in chat box so that we can start. Is it visible?
Yeah. Yes, sir.
Yeah. Okay. Thank you. Please, everybody in mute. If you have any question, you can unmute yourself and you can ask. Okay. Otherwise, please be in mute. So yesterday we started with section number 37 in safety chapter. So following that, we have covered chapter 4A, and we also covered chapter 5, which is welfare. Okay. Then also we entered into chapter 6 as well, which is working hours. So when talk about working hours, the normal working hours are 48 hours in a week, and weekly holiday should be there, and also compensatory off. If you are not able to take that weekly holiday, you should take the compensatory off within 2 months. Then daily hours, it should not spread more than 9 hours in a day, and you should have proper rest intervals in every 5 hours. Then spread over, it should not be more than 10.5 hours. Okay. Then night shifts, and also we talk about prohibition of overlapping of shifts, like people coming in the night shift and continuing the day shifts. I mean, first shift, second shift, etc. It should not be the case. Then extra wages. So whoever works 9 hours in a day or for more than 48 hours in a week, he shall, in respect of overtime work, be entitled to the wages at the rate of twice his ordinary rates. So whenever a person works for overtime, he has to get double than the normal ordinary rates. When you say ordinary rates, so if you calculate per hour, how much will be, for example, per hour it is 10 rupees. So if he done any extra time for those hours, he has to get per hour 20 rupees. Okay, that is how it is. Then restriction of double employment. So it is also one of the provision. So no adult worker shall be required or allowed to work in any factory or any day on which he has already been working in any other factory, save in such circumstances as may be prescribed. दो दो जगह पे हम लोग काम करना नहीं चाहिए. It is illegal. We are not supposed to work. Again, notice period. One second. So there shall be displayed and also correctly maintained in every factory in accordance with the provisions of subsection 2 of section 108. Notice period of the workers for adults showing clearly for every day and periods during the adult worker may be required to work. And also the period shown in the notice required by the subsection 1 shall be fixed beforehand in accordance with the following provisions of the section, and shall be such that a worker working on those periods should not be working in contravention of any provisions under 51, 2 and 3. So where all adult workers in a factory are not required to work during the same periods, the manager of the factory shall classify them into groups. And also where the adult worker in a factory are required to work during the same periods, the manager of the factory shall fix those periods for such workers generally. It is nothing but shift works, how it is required, or they will group the couple of people. That is how we go for first shift, second shift, and night shift. So it will be decided by the occupier. Then registers of the adult workers. So the manager of every factory shall maintain the registers. It is nothing but attendance register, wage register, etc. Okay. So here we'll have basically name of the adult worker and also nature of his work and group in which he is included, like department or etc. And where his group work on shifts they relate to be, which is allocated, and such orders particular may be prescribed. It is just maintaining the registers. And the power to make this not so important. Resumption of these rules. Yeah. Restriction of employment of women. So the provisions in this chapter shall be applicable to women in the factories be supplemented by the following restrictions. No exemption from the previous section 54 may be granted in respect of any woman. No woman shall be required or allowed to work in a factory except between the hours 6 a.m. to 6 p.m. So their maximum they should work 6 a.m. to 6 p.m. only in the daytime. Nighttime it is not supposed to be, but some of the organization they can get a special provisions from the inspector of factories where they can do the second shift. The night shift is strictly prohibited. So, provided that a state government may, by notification in the official gazette, in respect of any factory or group or class of description of factories, where a limits laid down in clause B, but so that no such variation shall be authorized, the employment of any woman between 10 p.m. to 5 p.m. Okay, 5 a.m. They should not, and should no longer change the shifts except after a weekly holiday, etc. Okay. Then employment of young persons. So when you say young, who is completed 14 years of age, but who is not completed, they're 18 years of age. So prohibition of employment of young children. No child who has not completed his 14th year shall be required or allowed to work in any factory. So here they're talking about children, young children. When you say children, who is below 14 years, and no adult worker to carry any tokens. A child who has completed his 14th year or an adolescent shall not be required or allowed to work in any factory unless a certificate of fitness granted with reference to his under section 69 in the custody of manager of the factory. And also such child or adolescent carries while he is at work a token given a reference of such certificate. It is nothing but any reference number or ID card, etc., so that they can carry when any non-adult workers like adolescents. So certificate of fitness. So the certificate of fitness will be taken from the certifying surgeon shall on application of any young person or his parent or guardian accompanied by a document signing by the manager of a factory that such person will be employed therein if certified to fit for the work in a factory. So whenever the parents or along with the guardian by signing off by the manager who can work in the factory if the adolescent get a fitness certificate from the certifying surgeon. Okay. Then working hours of children. So no child shall be employed or permitted to work in any factory for more than 4.5 hours in a day or during night shifts. Okay. For the purpose of subsection night shall be mean a period at least 12 consecutive hours which shall include or interval between 10 p.m. to 9 it says 10 p.m. to 6 a.m. that is night hours. Then register of child worker. So as like adult worker, so here we also carry the register for child workers same way. Here also you'll have name of the child and nature of work he is doing, under which group, whether the number of his certificate is granted or not. Then power to require medical examination, where an inspector, in the opinion that any person working in a factory without a certificate of fitness is a young person, or that a young person working in a factory with a certificate of fitness is no longer fit to work in the capacity stated there. Okay, so if he feels that, we have to take the fitness certificate from the. Then annual leave with wages. So when I say annual leave, every worker who has worked for a period of 240 days or more in a factory during the calendar year shall be allowed during the subsequent calendar year a leave with wages for a number of days calculated at the rate of, if an adult worker, 1 day for every 20 days of work performed by him during the previous calendar year. So these are the annual leaves or PLs or ELs we used to say. So if you work for 240 days, for every 20 days, we used to get one PLs, like paid
As of
leaves or
sir,
ELs,
as of
earned leaves. Sorry, any question?
yes, sir. As of now, every month 1.5 days leave. That means
हाँ वो
which
तो
is
है.
per,
Yes.
per
Now
year.
nowadays we are getting the 1.5 day for complete work. Correct. One
Yes,
month.
yeah, as per Factory Act as of now.
Same no. For
Ah,
20 days you are getting one. For balance 10 days you are getting half.
you're right.
Yeah. Okay. So I am taking, I mean, bit faster here. These sections are not so important, but just only few sections I have highlighted, which are relevant in our day-to-day activities. Okay. Yes. One more section here: dangerous operations. So here, where the state government is of opinion that any manufacturing process or operation carried on in a factory exposes any person employed in it to a serious risk of bodily injury, poisoning, or disease, it may take rules applicable to any factory or clause of description of factories where which the manufacturing process or operations carried out satisfy the manufacturing process or operation and declaring it as dangerous occurrence. First, it satisfy the definition of that. Then, prohibition or restricting employment of women, adolescents, or children. Then, providing periodical medical examinations of the operations employed, and also providing for a protection of all the persons employed in the vicinity of the place where it is carrying on. Okay, and prohibiting, restricting, controlling the use of any specified materials. Sometimes they will give us that, okay, you should not use these certain type of materials, those are restricted or banned or etc. And also requiring provision of additional welfare amenities, sanity facilities, supply of protective equipment, clothing, laying down the standards etc. should be followed for the dangerous operations. One is prohibition of employment of children, adolescent, and women, and also providing periodical medical examinations where such kind of poisoning happens or any chances of diseases which can occur with that operation, etc. Okay. Then notice of certain accidents. So when we talk about notice of certain accidents, so here where in any factory an accident occurs which causes death or which causes any bodily injury by reason of which the person injured is prevented from working for a period of 48 hours or more immediately followed the accident, or which is such nature may be prescribed in his behalf of manager of the factory shall be sent to a notice thereof to such authorities on which such form within the such time as may be prescribed. So here notice of certain accidents in the sense intimation of incident or intimation of accidents which has happened if a person he is not able to report back within 48 hours. Okay, I think there is one more provision with respect to the time and all. Here we will see in the factories rules. Just a second, I'll take you there itself. So here also you have register of workers, employment, notice of worker. Yeah, here is it. Notification of accidents. Here we have the section number 88, and here we have rule number 96. We'll go to the rule number 96. Okay. So if you go to rule number 96, what they've written here. So when any accident which result in death of any person or which result in such bodily injury to any person as likely to cause his death or any dangerous occurrence satisfied in the schedule taken place in a factory, the manager of the factory shall forthwith send a notice to the thereof by telephone, a special messenger, or a telegram to the inspector or deputy chief inspector. Okay. So here we have a form 18. We have seen form 18 during our IS 104 discussion. So form 18 we use for what? Form 18 and form 18A. Form 18 is for what and form 18A is for what? हम लोग किधर यूज करते हैं फॉर्म 18 कब यूज करते हैं और फॉर्म 18 हम कब यूज कर सकते हैं ఎక్కడ యూజ్ చేస్తాం
सर अभी तक तो हमें जरूरत
हाँ
नहीं पड़ी।
हेलो सर, गुड इवनिंग सर।
यस यस गुड इवनिंग हरिराम
सर
अच्छी
ये
बात है जब
फॉर्म
जरूरत नहीं पड़ेगा तो अच्छी बात है
सर ये तब यूज करते हैं जब कोई एक्सीडेंट इंसिडेंट हो जाता है, फेटल हो जाता है सर। उसके बाद ये
हाँ
फॉर्म 18A का इंश्योरेंस जो क्लेम होता है,
हाँ
और तब सर ये जरूरत पड़ता है।
हाँ आपका बात तो सही है 70%। जब 18 कब यूज करते
सर
हैं हम
व्हीकल
यस
सर
नमन
व्हीकल का जो आरसी बुक रहता है उसमें भी फॉर्म 18 अटैच रहता है। आई
व्हीकल में
थिंक व्हीकल का जो आरसी बुक होता है ना बाइक वगैरह का, तो उसमें भी
हाँ
फॉर्म
हाँ
18 इंक्लूड रहता है।
किसके लिए नवनीत
पता नहीं, मैं देखा था इसलिए मैं थोड़ा पूछा। उसमें भी यूज करते हैं इसको फॉर्म 18 को,
नहीं नहीं नहीं
फॉर्मेट को।
मे बी वो फॉर्म 18 अलग है जो फैक्ट्री एक्ट में जो फॉर्म 18 है वो अलग है दोनों डिफरेंट है उसका इसका वो कुछ संबंध नहीं है देयर इज नो रिलेशन बिटवीन दोज टू फॉर्म्स जब हम
यस
लोग
सर।
फॉर्म 18 यूज करते हैं कभी भी फैक्ट्री के अंदर जो एक्सीडेंट होके जो भी लोगों को नुकसान होता है मतलब इंजरी हो सकता है नहीं तो लोग मर सकता है नहीं तो कुछ हाथ पैर टूटा हुआ होता है तभी हम लोग फॉर्म 18 यूज कर सकते हैं जब आपको
और
जो एक्सीडेंट होता है बट किसी इंसान को इंजरी नहीं होता है खाली प्रॉपर्टी डैमेज होता है तब हम ये फॉर्म 18 यूज करता है ऐसा है द बेसिक डिफरेंस
सर
इज यस
सर ये फॉर्म 18 सर, कोई एक्सीडेंट इंसिडेंट होने से हम क्लाइंट को ये 24 आवर्स के अंदर अंदर उसको रिपोर्ट करना होता है फॉर्म 18 के फॉर्मेट में सर।
हाँ 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 फॉर्म 18 पे देना है करेक्ट सो
हम्म।
हियर व्हाट वी डू इज
यस
जस्ट अ
यस
second.
सर।
So a manager of the factory to the authorities mentioned in sub rule within 12 hours of accident or dangerous occurrence by sending them a written report by way of copy of accident report prescribed under employee state insurance regulations form 18 in the case of accident dangerous occurrence causing death here we have clearly written कोई भी डेथ इंजरी हो गया नहीं तो इंजरी हो गया ऑफ एनी पर्सन ओके एक एक चीज हो गया जो फॉर्म 18 यूज करता है इन द केस ऑफ एनी डेंजरस अकरेंस व्हिच हैज नॉट रिजल्टेड इन इंजरी इधर ही है मतलब एक हो गया जो इंजरी होगा तो हम 18 यूज करेंगे और मरा हुआ तो दूसरा हो गया जो इंजरी नहीं होता है तब हम 18A यूज करते हैं.
ओके सर, थैंक यू सर.
सर डेंजरस अकरेंस कैसे डिसाइड करते हैं सर?
So when you say dangerous occurrence, for example,
सर
any equipment got exploded but nobody injured. Any explosion happens, nobody injured. Any structural collapse, nobody injured. All these cases are dangerous occurrences.
सर उसमें, हाँ सर उसमें प्रॉपर्टी डैमेज हो सकता है, लेकिन कोई पर्सन को कोई इंजर्ड नहीं होता है, तो हम उसको
Correct.
डेंजर
Yes.
से.
Whatever the accidents which happens, there a person is not injured, but there is a high potential of injury, but it has not happened. Those cases called as dangerous occurrence. Okay. Sonu, would you please show us the Form 18? Definitely, Sonu. So no, what I do is I'll show you in the second half. Okay. First we'll conclude. I mean continue now. After the break, I'll show you the two forms. Okay. Don't worry. Again, I'm going back to Factories Act. Again, notice of certain dangerous occurrences where the factory any dangerous occurrence such as nature of prescribed occurs whether causing any bodily injury or disability or not. A manager of the factory shall send such authorities in such a form with the time prescribed. So within 12 hours of time we have to inform. Again, notice of certain diseases. So here we have seen notice of certain accidents and notice of certain diseases. When I say diseases, occupational diseases, as we have list in the schedule 3. So here, where any worker in a factory contacts any disease prescribed in the third schedule, here we have a third schedule where they have given the list. Okay, we'll see the list today. The manager of the factory shall send a notice thereof to such authorities in such a form, in such a time prescribed. We'll see what it is. So here we have notice of poisoning or disease. So here a notice in the form of 19 should be given. When I say should be sent forth with the chief inspector, that by the certifying surgeon, by the manager of the factory, in which there occurs a case of a lead, phosphorus, mercury, manganese, arsenic, carbon disulfide, or benzene poisoning, poisoning by nitrous fumes, or halogens, derivatives, hydrocarbons of aliphatic services, or chrome ulceration, anthrax, silicosis, toxic anemia, toxic uricase, etc., etc. So it has to be informed. We'll see Form 19 as well. Even these forms we can see in the DZ Fastly website itself. I'll show you where you can get these forms. Then power to direct inquiry in the case of any accidents. So here, who is having that authority? So the state government may, if it considers it expedite, so to do, appoint a competent person to inquire into the causes of any accident occurring in a factory or into any case where a disease specified in third schedule has been or is suspected to have been contracted in a factory, and maybe also appoint one or more persons prescribing legal or special knowledge to act or assessor in such inquiries. Once you have given the intimation saying that okay, one of my worker has been affected with so and so disease, then the inspector of factories will order for an inquiry. Okay. So again safety and occupational health survey. The the person or shall afford all the facilities for such survey, including facilities for examination, testing of the plant machinery, and collection of samples that data relevant to the survey. So even the inspector of factories will also collect the some of the samples, and also they do a survey with respect to the safety aspects. Then penalties and provisions. So here we have a couple of penalties and provisions. Few of them applicable, but not at this moment. I can say penalty for contravention of provisions of 41B, 41C, 41H. So where these sections? These sections are from chapter 4A. Okay. So in case of not meeting this requirement of these specific sections, if the failure or contravention refers to subsection 1 continues to beyond a period of 1 year after the date of conviction, the offender shall be punishable with imprisonment for a term which may extend to 10 years. If they are not following, or if they fail to do that, so what are they to? So whoever fails to comply with contraventions of any provisions of section 41B, 41C, and 41H of rules made under shall, in respect of such failure or contravention, be punishable with a imprisonment of for a term which may extend to 7 years, and with a fine which may extend to 2 lakhs rupees. And also in the case of failure or contravention continues, with additional fine which may extend to 5,000 rupees for every day. So what happens for the first instance, they'll have a certain penalty, but again you are repeating the same issue, then they will calculate per day 5,000 rupees into from number of days they used to calculate. I think same kind of provisions we have with the PCB as well. Then offenses by the workers. When you say offenses, so subject to the provision of section 111. When you say 111, it is nothing but, I'll go there, obligation of workers. We'll see first these obligations and 111A, then we go back. So here when you say obligation of workers, so no worker in a factory shall willfully interfere with or misuse any appliances or conveniences or other thing provided in a factory for purpose of securing the health and safety or welfare of the workers. Okay. So they should not damage any provisions which are made by the occupier for the safety of the people. And no worker shall willfully and without reasonable cause to do anything likely to endanger himself or others. So sometimes happen any unsafe action which is attempted by one employee, which can also affect the co-workers who are working with him. And no worker in factory shall willfully neglect to make use of any appliance or other thing provided in the factory for the purpose of securing the health or safety of the workers therein. Also, they should not neglect to make use of any appliances. When you say make use of any appliances, like emergency buttons or uh, PPEs, any other safety appliances which are provided by the employee. Okay, that is the obligation, means he has to follow. And section 111A, which is very important. So rights of the workers. One is obligation, means they must and should follow. And here what are their rights? So every worker shall have the right to obtain from the occupier information relating to workers' health and safety at work. So what are the various safety provisions or appliances which are in place. The workers should know that. That is their right. And also every worker shall have right to get trained within the factory wherever possible, or to get himself sponsored by the occupier for getting trained at a training center or institute duly approved by the chief inspector, where the training is imparted for the workers health and safety of the work. So if at all it required, even the occupier can sponsor the training which is required for the occupational health and safety of the employees. And also every worker shall have right to represent to inspector directly or through his representative in the matter of inadequate provision for the protection of his health or safety in the factory. So he has right to inform the inspector of factories in the case of any potential risk or the threat which is in the factory, which is not addressed by the occupier. One thing is, in the obligation part, he has to follow all the safety precautions or the appliances which are provided by the occupier, and also he should not willfully or without a reasonable cause do anything likely to himself put in danger or others. Third one, and no worker in a factory shall willfully neglect to make use of any appliances. So they should not neglect for use of appliances which are provided by the company. Okay. Now we'll see. Go back to the other one so that you will understand. Yeah. Offenses by the workers. So when you say subsection triple one is talking about obligation of workers. Whenever they do such mistakes, unsafe actions, or they misuse the safety related appliances, if any worker employed in a factory contravenes any provision of this act or any rules or orders made thereunder imposing any duty or liability on workers, he shall be punishable with fine which may extend to 500 rupees. So we can penalize them with a 500 rupees if somebody is not following, or where a worker is convicted of an offense punishable under subsection 1, I mean this one 97A 97(1), the occupier or manager of the factory shall not be deemed to be guilty of an offense in respect of that contravention unless it is provided that he failed to take all reasonable measures for its prevention. It means the occupier has to take the proper or reasonable provisions to prevent such attempts. Okay. Then penalty using a false certificate of fitness. I think this is not so important. Power of court make the orders. Okay, display of notice.